The day everything shifted. The rain started before sunrise. Not the gentle kind that taps politely against windows, but the relentless kind that makes the world feel heavier. By the time I reached the courthouse steps, water had soaked through the edges of my coat. The fabric clung to my arms, cold and stiff, as if trying to hold me back. I stood there for a moment, staring at the wide stone entrance. People were walking in and out, moving with purpose. They carried umbrellas, coffee cups, briefcases, normal lives continuing on schedule. For them, this was just another day. For me, it was the day everything would either collapse or finally stop. I tightened my grip on the folder under my arm. The cardboard edges had already softened from the rain. Dark patches spread across its surface, blurring its sharp lines. But inside, the papers were safe. That was what mattered. Paper survived when people didn't. Inside, the courthouse air felt dry and controlled, like nothing unpredictable was allowed to exist there. The faint smell of printer ink and old records filled the space. At the entrance, the bailiff checked names without looking up. His voice was flat, mechanical. When he said mine, he paused, just slightly. Not enough for anyone else to notice, but enough for me to feel it. I walked past him and into the courtroom, and that's when I saw them. My sister, Kendall, was already seated at the petitioner's table. She looked perfect. Not just presentable, perfect. Her hair fell in soft waves that hadn't been touched by rain. Her posture was relaxed, legs crossed neatly, fingers resting lightly on the table, as if she were waiting for lunch instead of judgment. Her lawyer sat beside her, scrolling calmly through his laptop. Behind them, my parents sat in the gallery, watching, waiting. My father's face carried that familiar expression, the one that said he already knew how this would end. My mother didn't even try to hide her impatience. Kendall saw me, her lips curved, not into a smile, into something quieter, something sharper. She leaned toward her attorney and whispered something that made him smirk too. I didn't react. I walked to my table, placed my folder down carefully, and sat. No announcement, no greeting, no performance, just paper. The clerk called the case. Everyone stood. The judge entered moments later. He moved with practiced efficiency, his robe swaying lightly behind him as he reached his seat. His expression was neutral, not kind, not cruel, just observant. He began scanning the room, petitioner's table, respondent's table, then he stopped, his eyes fixed on me, not casually, not professionally, personally. He leaned forward slightly, squinting as if trying to confirm something he hadn't expected to see. His lips parted, and quietly, almost to himself, he said, "I didn't expect to see her here." The words were soft, but in a silent courtroom, softness carries. Kendall's smirk faded instantly. Her lawyer froze mid-motion. Behind her, my parents shifted. The judge cleared his throat, regaining composure. "Let's proceed," he said. Kendall's attorney stood confidently. "Your Honor, this matter is straightforward. My client believes the respondent manipulated the decedent during her final months and improperly influenced the estate distribution. We're requesting corrective action and full control of the estate assets." He spoke smoothly, practiced, like he had delivered the speech many times before. Kendall leaned toward me, her voice barely audible. "You can still end this," she whispered. I didn't look at her. Because I hadn't come to end it, I had come to stop it. "My client has evidence," my attorney said calmly, standing beside me. The judge nodded. "What kind of evidence?" Without saying a word, my attorney reached into my damp folder. She removed a single document sealed in a clear protective sleeve. She handed it to the clerk. The clerk examined it briefly. Then his posture changed, subtle, but unmistakable. He handed it to the judge. The judge read the first line, then the second. His eyes slowed, focused. He looked at the seal at the bottom, ran his thumb over its raised surface, and read it again. "This," he said carefully, It's a recorded deed. The words landed heavily. Kendall's attorney stood abruptly. Your Honor, that's not relevant to. It transferred ownership, my attorney said calmly. Yesterday. Silence. Not confusion, recognition. The judge turned toward Kendall. His gaze sharpened. Did you file this document? Kendall hesitated, just briefly. My attorney handled the paperwork, she said. Her confidence was thinner now. The judge leaned forward. Clerk, he said, verify the recording details immediately. The clerk began typing, and that's when the courtroom door opened. A man stepped inside. He wasn't dressed like anyone else there. His suit was clean, but not courtroom formal. He carried no briefcase, just a thin file. He walked directly to the clerk, showed a badge, whispered something. The judge noticed immediately. Identify yourself, he said. The man turned. Investigator Daniel Halpern, he replied. Financial Crimes Division. Everything shifted, not loudly, but permanently. Kendall's lawyer stiffened. My parents stopped breathing. The investigator placed his file on the clerk's desk. There's an active fraud alert connected to that deed, he said calmly. The words didn't echo, they settled. Heavy, permanent. The judge opened the file, read silently, then looked up. At this time, he said carefully, the court is placing an immediate hold on any transfer, sale, or modification of the property. Kendall's composure cracked. What? She said. You can't. I can, the judge said, and signed the order, just like that. The clerk stamped it. Permanent ink, permanent record, permanent consequences. Kendall stared at the paper like it had betrayed her. Her lawyer leaned toward her urgently. My parents said nothing. For the first time in years. They had no script, no control, no certainty. The investigator remained still, watching, waiting. Because this wasn't the end, not even close. As the judge finished signing, he looked directly at Kendall and asked one simple question. One question that would change everything. Were you present? He said. When this document was signed, Kendall opened her mouth and hesitated. That hesitation lasted less than a second. But in court, a second is all it takes. Because the investigator was already reaching into his file, pulling out something else. Something that hadn't been mentioned yet. Something Kendall clearly didn't expect. And when he placed it on the desk, her face lost all color. Because the document the investigator just revealed didn't just question the deed. It proved someone had lied under oath, and the next 5 minutes would decide whether Kendall walked out of that courtroom free or under investigation for a crime she could never undo. The first crack in the lie. The paper made almost no sound when investigator Halpern placed it on the clerk's desk, but the silence that followed was louder than anything else that had happened all morning. The judge didn't rush. He picked up the document slowly, the way people do when they already suspect what they're about to see. His eyes moved across the page, then stopped. His expression didn't change immediately, but something behind his eyes did. He looked up, not at me, at Kendall. Mems Pierce, he said calmly, I'm going to ask you again. His voice was steady, controlled, precise. Were you physically present at the signing of this deed yesterday? Kendall sat perfectly still. Her hands rested on the table, fingers lightly touching, like she could hold herself together if she didn't move too much. No, she said. Just one word. Clean. Certain. Final. Investigator Halpern didn't interrupt. He didn't argue. He didn't even look surprised. He simply spoke. The document I just provided, he said, is the appointment confirmation for the notary. The judge glanced down again. The signing location, Halpern continued, was a private shipping center located 2 blocks from the petitioner's attorney's office. Kendall's attorney froze. Not dramatically, not obviously, but enough. The judge turned his attention to him. Counsel, he said, were you aware of this scheduled signing? The attorney hesitated. That hesitation mattered more than anything he could have said. Yes, he answered carefully. My office arranged a neutral location for convenience. Convenience, such an innocent word. Such a dangerous one. The judge leaned back slightly in his chair. And your client is telling this court she wasn't present. No one spoke. The air in the room felt thinner now. Harder to breathe. Kendall shifted in her seat. This doesn't prove anything, she said. Her voice was sharper now. Less controlled. People schedule things all the time. Halpern nodded once. That's true, he said. Then he reached into his file again and removed another document. This time, he handed it directly to the judge. The judge scanned it quickly, then more slowly. His jaw tightened. He turned the page toward Kendall's attorney. This, he said, is a transaction record. Kendall's attorney leaned forward. His eyes moved across the paper, then stopped. He didn't speak. Because he couldn't. The judge said it for him. It shows payment for notary services, he said. He paused, then added, paid at 11:14 a.m. yesterday. The courtroom was silent. Paid, the judge continued, hoosing a card issued in the name of Kendall Pierce. Kendall's head snapped up. That's not possible. But her voice didn't sound certain anymore. It sounded defensive, cornered. Halpern remained calm. The transaction was processed at the same location, listed in the appointment confirmation. The judge looked at Kendall. His expression hadn't softened, hadn't hardened. It had simply become clearer. Are you still telling this court, he asked, that you were not present? Kendall opened her mouth, closed it. Her attorney leaned toward her, whispered something urgent. She nodded quickly. Less, she said. The word came out faster this time, too fast. The judge watched her for a moment, then nodded slowly. As you wish. He looked at Halpern. Is there anything further? Halpern answered without hesitation. Yes, Your Honor. He removed one final page from his file. This one wasn't a receipt or a confirmation. It was something simpler, something harder to explain away. A scheduling log, he said. The judge examined it. This log, Halpern explained, was provided by the notary's appointment system. He paused. It shows the appointment was confirmed using a phone number registered to Miss Kendall Pierce. Kendall's attorney leaned forward sharply. Phone numbers can be used by anyone, he said quickly. Halpern nodded again. Yes, he said, they can. He didn't argue. He didn't need to, because the judge was already reading the rest. The system also records device identifiers. Halpern added. He pointed to a line on the page. This identifier matches a device currently active under Ms. Pierce's name. Kendall's breathing had changed. Not visibly, but audibly, small, uneven. The judge placed the document down carefully. Ms. Pierce, he said, you are under oath. 3 simple words, heavy with meaning. Do you wish to revise your statement? Kendall didn't answer immediately. She looked at her attorney. He didn't look back. He was staring at the table, at the papers, at the evidence that wasn't supposed to exist. She began, then stopped. For the first time since this had started, she looked unsure. My parents sat frozen behind her. My father stared straight ahead, like he could disappear if he didn't move. My mother's lips pressed into a thin, tight line. No one was coming to save her. The judge waited, not impatient, just certain. Finally, Kendall spoke. I don't remember, she said quietly. It wasn't a denial. Not anymore. It was something weaker, something smaller. Halpern didn't react. He simply added, there's one more item, Your Honor. The judge looked up. Halpern placed a final document on the desk. A security image, he said. The judge examined it. His eyes sharpened. He turned it toward Kendall. Even from where I sat, I could see it clearly. A timestamp in the corner, a counter, a clipboard, a notary stamp, and Kendall, standing there, holding a pen. Her attorney went completely still. Kendall stared at the image, her face pale. That's Bao, she began. But there was nowhere for the sentence to go, because the evidence wasn't asking questions anymore. It was answering them. The judge leaned forward. "Emmons Pierce," he said quietly. His voice carried no anger, only certainty. "This court does not rely on assumptions." He paused. "It relies on records." Kendall said nothing, because for the first time in her life, the record didn't belong to her. The judge picked up his pen again. "The property remains frozen," he said, "and this matter will proceed to full evidentiary review." He signed another order, ink on paper, permanent, unavoidable. Kendall's attorney leaned toward her, whispering urgently, planning, adjusting, trying to repair something that was already broken. But Kendall wasn't listening anymore. She was staring at the image, at the proof, at the moment everything had turned against her. Because lies only work until someone saves the receipt. But the security image wasn't the worst part, because the investigator had also requested the notary's official journal, and what was written inside it didn't just contradict Kendall's story. It exposed a decision she made that could cost her everything. The record that couldn't be erased. The courtroom had changed. Not physically. The same walls stood. The same flags hung behind the judge's bench. The same faint hum of fluorescent lights filled the silence. But something invisible had shifted. Before, Kendall had controlled the room with confidence. Now, the room was controlling her. She hadn't moved since the security image was shown. Her hands rested flat against the table, fingers spread slightly, like she needed to feel something solid beneath them. Her attorney leaned close, whispering rapidly, his voice tight with urgency. But Kendall barely reacted, because the illusion she had built was no longer holding. Investigator Halpern stood quietly, his file still open. He wasn't rushing. He wasn't dramatic. He didn't need to be. Truth didn't perform. It waited. "Your Honor," he said calmly, "there is one additional document the court should review." The judge nodded once. Halpern removed a thin sheet of paper and handed it to the clerk. The clerk examined it briefly, then passed it to the judge. The judge's eyes moved slowly across the page. His expression remained neutral, but the silence stretched longer than before. Kendall's attorney shifted. "Your Honor," he said carefully, "may I ask what that document is?" The judge didn't answer immediately. Instead, he looked directly at Kendall. "This," he said, "is a copy of the notary's official journal entry." Kendall's head lifted sharply. Her eyes locked onto the paper in the judge's hand, not with curiosity, with fear. Because the notary journal wasn't optional. It wasn't flexible. It wasn't something you could explain away. It was permanent, and it told the story exactly as it happened. The judge read aloud. The journal entry lists the signer present as Kendall Pierce. The words landed cleanly. No emotion, no accusation, just fact. Kendall shook her head immediately. "That's wrong," she said. Her voice sounded thinner now, less controlled. "I didn't sign anything as myself." The judge didn't react. He continued reading. "The journal also records the form of identification presented." He paused briefly, then added, "A driver's license, issued to Kendall Pierce." Kendall's attorney stood quickly. "Your Honor," he said, "notary records can contain clerical errors." The judge raised a hand, and the attorney stopped, because the judge wasn't finished. "The journal includes a signature," the judge said. He turned the paper slightly, examining it. A signature matching the name Kendall Pierce. Silence filled the room again. Kendall's breathing had become uneven. Her attorney leaned toward her again, whispering. Desperate now, Kendall shook her head faintly, like she could deny it away. But the paper didn't care what she believed. The judge looked at her. "Ms. Pierce," he said calmly, "this journal entry places you physically present at the signing." He paused. "And acting in your own name." Kendall swallowed. Her throat moved visibly. "I was helping," she said. The words came out quietly. Carefully chosen. I was helping my grandmother. The judge tilted his head slightly. Helping, he repeated. Yes? Kendall said quickly. She wanted it done. The judge's voice remained steady. Did you possess legal authority to act on her behalf? Kendall hesitated. That hesitation mattered, because authority wasn't emotional, it wasn't implied, it wasn't assumed, it was documented. She began. Her attorney leaned closer, but Kendall finished the sentence herself. No. The word barely escaped her mouth. But it changed everything, because intent didn't matter without authority. The judge nodded slowly, then looked down at the deed again. This document, he said carefully, attempted to transfer ownership of estate property. He paused. And you executed it without legal authority to do so. Kendall's attorney stood again. Your Honor, my client believes she was acting appropriately. Belief, the judge interrupted calmly, does not replace legal authority. The attorney stopped, because there was nothing else to say. Halpern spoke again. There is also the matter of the notary's commission status. The judge nodded. I'm aware, he said. He looked at Kendall. The notary who conducted this signing did not hold an active commission at the time. Kendall blinked rapidly. Her attorney stiffened. Because that fact created a second problem, not just unauthorized action, invalid authentication. The judge leaned forward slightly. This means, he said carefully, the document's legal validity is in serious question. Serious question. Such polite words. For something that was already collapsing. Behind Kendall, my parents remained silent. My father stared downward, his jaw tight. My mother's expression was rigid, controlled, but beneath it, something else had begun to show. Not anger, not sadness, fear, because for the first time, the outcome wasn't something they could influence. It belonged to the record now. And the record didn't love anyone. The judge turned to Kendall's attorney. Counsel, he said, do you wish to provide any documentation granting your client authority to execute this deed? The attorney hesitated. He knew the answer, but he still had to say it. No, Your Honor. The judge nodded once, not surprised, just confirming. He picked up his pen again. The movement was small, ordinary, but everyone in the room understood its weight, because judges didn't need raised voices, they only needed ink. He wrote briefly, then placed the pen down. The property will remain under court protection, he said. And this document will be subject to formal authenticity review. Kendall's hands curled slightly against the table. This isn't fair, she said quietly. The judge looked at her, not harshly, not kindly, simply honestly. This court does not measure fairness, he said. It measures evidence. Kendall looked down, because evidence wasn't something she could argue with. It was something she had created, without realizing it would one day be used against her. Halpern closed his file slowly, but he didn't leave, not yet, because there was still something unresolved. He spoke again. Your Honor, he said, we have submitted a request for the notary's full journal archive. The judge nodded, and Halpern's expression remained calm. It includes additional entries. He paused, then added, entries that suggest this may not have been an isolated incident. The words hung in the air, heavy, unfinished. Kendall's attorney froze. My parents shifted behind her. Even the judge's expression sharpened slightly, because this was no longer just about one document. It was about pattern, and pattern turned mistakes into intent. Kendall looked up suddenly. What does that mean? She asked. Halpern met her eyes. It means, he said calmly, this investigation is still ongoing. The judge leaned back slightly, his fingers resting lightly on the bench. Because what happened next wouldn't just affect the estate. It could affect everything. Because later that same day, investigators would uncover something even more damaging. A digital trail Kendall thought she had deleted. One that didn't just prove she signed the deed, but proved she had planned it weeks in advance. The trail she thought was gone. By the time the hearing paused, Kendall was no longer the same person who had walked into the courtroom that morning. Confidence had been replaced with calculation. Her posture was still straight, but it wasn't relaxed anymore. It was rigid, like she was holding herself together by force. Her attorney stayed close beside her, whispering constantly. His earlier smooth confidence had been replaced with urgency. Every few seconds, he glanced toward investigator Halpern, then back to his client, like he was trying to predict the next blow before it landed. But Kendall's focus wasn't on him. It was on the judge's bench. Because for the first time in her life, she wasn't controlling the outcome. She was waiting for it. The judge reviewed the last of the documents in front of him, his expression unreadable. When he finished, he looked toward Halpern. "You mentioned additional entries," the judge said, "and a broader investigation." Halpern nodded. "Yes, Your Honor." He stepped forward slightly, his voice calm and steady. "Our office obtained authorization this morning to review communication records associated with the scheduling of the signing." Kendall's attorney stiffened immediately. "Your Honor," he said quickly, "I object to any discussion of communications without full context." "This is not testimony," the judge replied evenly. "This is procedural clarification." The attorney stopped, because he knew better than to push further. Halpern continued. "The notary appointment wasn't arranged randomly," he said. He opened his file and removed another document. It was scheduled through an email account. He handed it to the clerk. The clerk passed it to the judge. The judge read silently, then looked up. "This email," he said carefully, "originated from an account registered to Kendall Pierce." Kendall's face tightened. "That doesn't mean anything," she said quickly. "People use email all the time." Her voice sounded defensive now, less controlled. Halpern didn't argue. He simply continued. "The email wasn't just a request," he said. "It included specific instructions." The judge looked down again. His eyes scanned another line. He read it aloud. "I need this completed quickly before the hearing date." The words settled heavily into the room. Kendall's attorney leaned forward. "Your Honor," he said, "that statement could refer to many things." "It refers to timing," the judge said calmly. He looked at Kendall. "Timing that coincides directly with this court proceeding." Kendall shook her head. "You're twisting it," she said. But the conviction in her voice was fading. Because timing wasn't emotional, it was measurable. Halpern stepped forward again. "There's more." He removed another sheet. "This is a metadata report." The judge accepted it. His eyes narrowed slightly as he read. "The email was sent 12 days ago," he said. He looked at Kendall. 12 days before today's hearing. That mattered, because it meant preparation, not reaction. Planning. Kendall's fingers curled tightly against the edge of the table. She didn't speak. Her attorney did. "My client was attempting to resolve family matters efficiently," he said. Halpern nodded slightly. "That may be her explanation," he said, "but the digital record shows deliberate coordination." He paused. "Heat escalation?" The judge leaned back slightly. "Escalation." Halpern turned another page. "This is a follow-up message," he said. The judge read it silently, then aloud. "Make sure everything is finalized before anyone can interfere." The courtroom went completely still. Even the air felt heavier. Kendall's attorney closed his eyes briefly. Just for a moment. Because he knew what that sounded like. Intent. Kendall's voice broke the silence. "That's not what it means," she said quickly. "I was protecting what was mine." The judge looked at her carefully. "Was it yours?" She didn't answer. Because ownership wasn't decided by emotion. It was decided by law, and law didn't bend for belief. Halpern spoke again. "The account activity also shows file attachments." He handed over another document. The deed draft was attached to the email. The judge examined it. The same deed later recorded? He said. Halpern nodded. Yes, Your Honor. That mattered more than anything else, because it proved sequence, draft, email, scheduling, signing, recording, not confusion, not accident, process. Kendall stared at the table, her breathing uneven now. Behind her, my parents remained silent, but their silence had changed. It wasn't confident anymore. It was cautious, uncertain, because this wasn't something they could dismiss. It wasn't argument. It was trail. The judge placed the documents down carefully. Ms. Pierce, he said. She looked up slowly. These communications show prior knowledge and coordination. He paused. Do you dispute sending these emails? Kendall hesitated. Her attorney leaned toward her urgently, but Kendall answered herself. No, she said quietly. The word barely escaped, but it sealed something, because acknowledgement created ownership. Ownership created responsibility. The judge nodded once, then spoke carefully. This matter will proceed to full evidentiary determination. He picked up his pen again, signed another order, permanent, final, unavoidable. Kendall watched him sign it, her expression hollow now, because for the first time, she understood something she hadn't before. Evidence didn't care about intention. It only cared about truth. Halpern closed his file. But before stepping back, he added one more thing. Your Honor, he said, there is an additional digital request pending. The judge looked at him. What kind of request? Halpern answered calmly, device extraction authorization. Kendall's head snapped up. Fear, real fear, not performance, not strategy, fear, phones. Halpern clarified, computers. He paused. Any device used in connection with this filing. The judge nodded slowly. Understood. Kendall's attorney spoke quickly. My client will cooperate fully. But Kendall didn't say anything, because cooperation wasn't something you offered when you were confident. It was something you offered when you had no other choice. The judge looked at Kendall one final time. This court will reconvene for final evidentiary ruling. He paused. And all findings will be based on verified record. He struck the gavel once. Sharp, final, and just like that, the performance was over. Only truth remained. Kendall stayed seated for a moment longer, not moving, not speaking, because for the first time in her life, she wasn't ahead of the consequences. She was behind them, and they were getting closer. Because 3 days later, investigators would unlock Kendall's phone and discover a deleted message she never expected anyone to read. A message that didn't just prove what she did, but proved she knew it was wrong when she did it. The message she couldn't take back. 3 days later, Kendall's phone stopped being just a phone. It became evidence. She didn't hand it over willingly at first. Her attorney had advised caution, careful compliance, controlled cooperation. But caution didn't stop court orders, and cooperation wasn't optional anymore. When the authorization came through, there was no delay left to create. The device was surrendered. And with it, everything Kendall thought she had already erased. Because deletion didn't mean disappearance. It meant delay. Digital forensics didn't look at what was visible. It looked at what remained. Fragments, metadata, ghosts of actions people thought were gone forever. Investigator Halpern sat across from a forensic analyst in a quiet office, reviewing the extraction report as it completed. The progress bar on the screen moved slowly, methodically. There was no urgency in the room, only certainty. Because devices didn't panic. They remembered. When the extraction finished, the analyst leaned back slightly. It's all here, she said. Halpern nodded. Show me communications from the week before the signing. She typed quickly. Messages appeared in chronological order. Most of them were ordinary, scheduling, questions, follow-ups. But then, one thread stood out, an unsent draft, saved, never delivered, but never erased completely. Halpern leaned forward. Open that. The analyst clicked. The message appeared on screen. Simple, short, permanent. Once this is signed, it won't matter what she says in court. Halpern didn't speak immediately. He didn't need to, because intent didn't get clearer than that. The timestamp placed the draft 2 days before the notary appointment, 2 days before the deed, 2 days before Kendall had walked into the courtroom and sworn she wasn't involved. The analyst looked at him. Draft folder. She said quietly, "People forget those exist." Halpern nodded slowly. "They always do." Because drafts weren't performance. They were honesty without audience. He printed the page and prepared to bring it back where it belonged. The courtroom The final evidentiary hearing was quieter than the first. No smirks, no confidence, no performance. Kendall sat beside her attorney, but she looked different now, smaller. Not physically, emotionally. Her posture was still straight, but it lacked certainty. Her hands rested motionless in front of her, fingers lightly touching. She didn't look at me. She didn't look at anyone. She stared at the table, because the table didn't judge. The judge entered and took his seat. "Proceed," he said simply. Halpern stepped forward. "Your Honor," he said, "we have completed device extraction." He handed the printed report to the clerk. The clerk passed it to the judge. The judge read silently. His expression didn't change, but the silence stretched longer than before. He reached the printed draft message. "Read it again." Then looked up. "Pierce," he said. Kendall lifted her head slowly. "This message was recovered from your device." He paused. "It states, once this is signed, it won't matter what she says in court." The words sounded heavier spoken aloud. Kendall's attorney leaned forward quickly. "Your Honor, draft messages do not necessarily represent intent. They represent thought," the judge said calmly. He looked at Kendall again. "Did you write this?" Kendall didn't answer immediately. Her attorney whispered urgently beside her, but Kendall didn't look at him. She stared at the paper, at the sentence she never expected anyone to read. And finally, "Yes," she said. The word was barely audible, but it was enough. Because acknowledgement didn't need volume. It needed truth. The judge nodded slowly, then spoke carefully. "This court has reviewed the full record." He paused. "The deed in question was executed without legal authority." Another pause. "It was notarized by an individual without valid commission." He glanced at the recovered message. "And it was coordinated in advance." He picked up his pen. The room held its breath. "This court finds the deed invalid." Ink-touched paper. Permanent. Final. The property remains part of the estate. He signed again. "And corrective action will be recorded immediately." Kendall's shoulders dropped slightly. Not dramatically. Just enough. Because consequences didn't need to shout. They simply arrived. The judge continued. "This court also awards legal costs to the respondent." He looked directly at Kendall. "Any further interference with estate assets will result in additional penalties." He set the pen down. "It is so ordered." The gavel struck once. Sharp, unavoidable, finished. Outside the courtroom, everything felt quieter. Not peaceful, just settled. Kendall exited slowly beside her attorney. She didn't look at me, didn't speak, didn't argue, because there was nothing left to argue with. The record had already spoken. My parents followed behind her. My father avoided my eyes completely. My mother looked at me briefly, not with anger, not with apology, just distance, because distance was easier than acknowledgement. I walked past them, out into the open air. The rain had stopped. The sky was clear now. For the first time in weeks, my hands didn't feel heavy. Not because I had won, because it was over. A week later, I stood at the county recorder's office. The clerk reviewed the judge's order, stamped it, filed it. And just like that, the correction became part of the permanent record. No speeches, no celebration, just ink. Because paper didn't need emotion, it only needed truth. Kendall didn't contact me again after that. She didn't challenge the ruling, didn't try to explain, because explanation didn't change documentation, and documentation didn't forget. My parents stayed quiet too, because silence was easier than admitting they had chosen the wrong side. The house remained where it belonged, not because I fought harder, but because I let the record speak. Because truth didn't need volume, it needed evidence, and evidence didn't care who you were, only what you did. I changed the locks myself, not out of anger, out of closure. Standing in the doorway, I realized something simple. This was never about revenge. It was about protection, not just of property, but of truth, because some people believe confidence makes things real. But confidence isn't proof. Paper is. And once something becomes part of the record, it never forgets. If you were in that position, and someone you trusted tried to rewrite the truth behind your back, would you stay silent to keep the peace, or would you let the record expose everything? Because sometimes, the most powerful thing you can do is nothing at all, except keep the evidence.